Welcome, folks, to this latest webinar in our series here at George Washington University Law School. The session is on new directions in international development, procurement in a increasingly global procurement world. We have three sessions this week on July 20th, 22nd, and 24th. Each of the sessions will start at the same time, which is 9 o'clock Eastern Time, 1500 hours in Central European Time, and 1830 in India. We are going to be going through several different topics over the course of these days. Recordings will be available from the session. They will be available at publicprocurementinternational.com and at the GW Law Government Procurement Law YouTube page as well. Those recordings should be available later this afternoon. They'll also be posted at the program page, and the program page is in the chat. As we go along, please feel free to posit questions in the chat, and we'll be responding to those questions. The public back and forth in those chats will become part of the record of this. It will be linking in and embedding in on the program page at publicprocurementinternational.com. I should emphasize we have a number of speakers here in various capacities, that their statements are in their personal capacities today, and we're very, very grateful that they could join us. I'm Chris Yukins. I'm the Lynn David Research Professor of Government Procurement Law at George Washington University Law School. I've been a professor since 2002, and I worked very closely with Caroline Nicholas and on the development of the UN Model Procurement Law that we'll be spending a lot of time talking about today. We were very pleased that we have almost 450. This morning we have almost 450 registrants from 85 countries from around the world. We're very, very grateful that you could all join us. We really make a very strong effort to bring together the international procurement world. It's a globalizing world. On Friday, Caroline and I were presenting together in Kosovo, and we're very enthusiastic about a very, very high level of professionalism and understanding of procurement in Kosovo when we were there, and that's a scene that's replicated over and over and over again around the world. That this is the procurement world is advancing incredibly quickly, and we're very, very grateful that we can be part of that as we move forward. My co-moderator today is Benedetta Audia. She is the principal of International Development, a firm advising private sector companies in international development and business matters, and providing counsel to multilateral organizations, non-governmental organizations, and government entities on a wide array of issues, including United Nations privileges and immunities, due diligence, investigations, funds receipt and disbursement, project design, and dispute settlement. Before establishing International Development LLC, she was a partner at DLA Piper, where she founded and chaired the firm's global international development practice. Before she joined the DLA Piper, she spent almost 2 decades working at the United Nations as a corporate legal advisor, where she conceptualized the legal architecture of thousands of multi-million-dollar projects implemented in developing countries, where she traveled extensively to lead negotiations with high-level government officials. So Benedetta's going to say a few words, and then I'll go ahead and I'll introduce the rest of the panel. Benedetta?
Thank you. Thank you, Professor Yukins. So I thought that perhaps it'd be good to put things in context and just talk a little bit about what international development actually is. And so when we talk about international development, what we're really talking about is the transfer of resources, expertise, and institutional capacity to communities that lack them. And the goal is to build something durable, functioning health systems, roads that survive a rainy season, schools that stay open, institutions that outlast the project cycle. This is one of the very few fields where the stakes are not abstract. When international development as a system works, children survive. People who need medicines get them. Bridges don't fall. But when it fails, the failure is not theoretical either. And this is why the mechanics of how development actually happens matters as much as the policy behind it. And so procurement is important because it's not just the back office. Is where development policy actually gets tested against reality. And so every principle that we debate at the policy level, like transparency, value for money, local ownership, anti-corruption, gets decided in the procurement file, not the strategy document. And so when we talk about new directions in procurement, we're really talking about three shifts happening at once. The very first one is structural. The donor landscape has changed dramatically in a very short period of time. With USAID's dissolution as an operational entity, a significant share of procurement volume and expertise that used to run through a single dominant bilateral channel has now scattered across several multilateral institutions, private contractors, and really blended finance vehicles. The second shift is about who sits at the table. Procurement used to be a conversation between donor agencies and traditional implementation partners, but now it really includes private contractors and commercial actors who bring not only capital and delivery capacity, but also that fiduciary, discipline that multilateral procurement rules are trying to enforce. The last shift, and then I'm going to give the floor to the next panelist, is really technological. And everyone here will spend some time there, right? Data analytics and AI are starting to do and AI-enabled tools are starting to do the fraud detection and vendor vetting work that used to depend entirely on human audit capacity. And that is genuinely promising for institutions that never had to staff to do it well, but also procurement rules were built around due process, contestability, and a vendor's right to know why they lost the bid. So there are a few things that need to be fully worked out, and it's important to understand also how these due process protections survive contact with automated decision making. So I'm raising these threads just again to start the discussion, but I'm going to give you the floor back, Chris. Thank you.
Thank you very much. Thanks for that context, Benedetta. So we have three sessions this week. Today is the introduction and an overview of key issues, such as Benedetta just went through. On Wednesday, we'll be talking about contracting and international development, and on Friday, we'll be talking about anti-corruption issues in international development. Just want to quickly go through our speakers. We have Prabhat Garg. He's an international program management and public procurement expert with about 40 years of experience with multilateral development banks and bilateral development partner agencies working across the globe in various countries, including in the former Soviet Union region. He worked at the World Bank from 1984 to 2000, where he designed and managed international programs, policies, projects, and procurements. In 2006, he joined the U.S. federal government working on international public procurement. We worked in senior executive services, SES, grade levels, leading an international public procurement practice group to develop policies and manage procurements funded by the U.S. government's foreign aid agency, the Millennium Challenge Corporation, or the MCC. Benjamin Herisset is a legal officer in the United Nations in the Office of Legal Affairs, International Trade Division, and the UNCITRAL Secretariat, where he has served since 2017. He'll be working on an update of the UNCITRAL Model Law on Public Procurement through UNCITRAL's Working Group 1. He's also in charge of managing cooperation with Francophone countries, especially in Africa, on various UNCITRAL matters. Before joining the United Nations, he worked as a lawyer in various international law firms in Ho Chi Minh City and Paris, and as a legal project officer and technical assistance in legal reforms in the French Embassy in Hanoi. He holds a master's in international and European comparative law from the University of Paris 2 Panthéon-Assas. Jun Jin serves as the General Counsel and Director of the Office of Legal Services at the UN Development Program, or UNDP. He's a seasoned legal executive with over 25 years of experience in international development, humanitarian and administrative law, who previously led a global team of legal practitioners at USAID to provide strategic legal counsel to agency officials on high-profile programs. He's recognized as a leader and coalition builder in the development and humanitarian assistance legal community across multilateral and bilateral agencies, for-profits and private companies, nonprofit organizations, foundations, philanthropies, and U.S. government interagency legal community. The U.S. government interagency legal community. Jun is also a graduate of our program. We're very, very proud and happy to have him here with us today. Caroline Nicholas served as a senior legal officer with the International Trade Law Division of the United Nations Office of Legal Affairs, the UNCITRAL Secretariat. She also served as secretary to its working group on procurement and infrastructure development, which drafted the UNCITRAL Model Law on Public Procurement issued in 2011, and an accompanying guide to enactment published in 2012, and other UNCITRAL documents in the field. She advises on public procurement reform and its role in supporting international trade and development and the rule of law, and provides regular financial technical assistance to national governments in all regions. She's a member of the editorial board of the Public Procurement Law Review and a regular contributor to it and other journals. And as I mentioned, Caroline and I were presenting in Kosovo on Friday. She and I have done many missions around the world, and she, for those of you working in this area, so that you know, she was very much the force behind the UNCITRAL Model Law, the Guide to Enactment. She's made a tremendous contribution to this field of procurement and international development. Vinay Sharma is recognized as a distinguished authority in international public procurement, governance, and institutional reform with over 35 years of global experience spanning multilateral development banks, public infrastructure enterprises, and high-level advisory roles, linking fiduciary integrity with development and effectiveness, market creation, and institutional trust. He began his career in India's public sector infrastructure enterprises, working on large rail and urban transport projects. He subsequently transitioned to international development finance, serving in senior leadership roles at the African Development Bank and the World Bank. In those capacities, he led major policy reforms, contributed to the modernization of procurement frameworks, strengthened fiduciary oversight systems, and supported operations across Africa, Asia, Europe, and fragile and transition economies. He's a co-author of a book on procurement in international development, and that book is available. Is going to be published in the next few months, and it is linked on the resources section of the program page, which I put in the chat very early on. Jean-Jacques Verdeau is currently the procurement practice manager for the Latin American and Caribbean region of the World Bank. He's a U.S.-French educated lawyer who first joined the bank in 2002 as a senior procurement specialist in the Africa region, and he's held since then various positions, including senior counsel in the legal procurement group, procurement coordinator for the Andean countries, and lead procurement specialist for the Middle East and Northern Africa. Before his current assignment, he worked at the European Investment Bank in Luxembourg, where he was the senior procurement advisor for the Energy Department. In his current position as manager for Latin America and the Caribbean, he leads a team of more than 35 World Bank procurement specialists who supervise operations in 32 countries. Jean-Jacques graduated from GW, from our law school, with an LLM in federal government contracts in 2002. I should note that his piece, published in 2003 in the Public Contract Law Journal on the EU directives, was our first really breakthrough comparative piece. We've had many since then, and Jean-Jacques was very much a leader in helping build GW law into an international program. We remain very grateful for that. He also has a degree from the University of Lorraine at the Faculté de Droit de Nancy, and is admitted to the Paris Bar. Last but not least is our newest colleague at GW Law School. Shopei Williams should be joining us on Friday to discuss anti-corruption matters. She'll be joining us, as I said, in August 2026. She's a professor of public procurement law, a procurement law consultant, and the deputy director of the African Procurement Law Institute unit at Stellenbosch University in South Africa. She's an expert in procurement law and policy in Africa, procurement in the multilateral development banks, gender-responsive procurement, emergency contracting, sustainable public procurement, and anti-corruption law. And I'm very, very excited that both of you should be joining our faculty and that you'll be able to join our session on Friday as well. So with that, I'm going to go ahead. We can start walking through the substance of these 3 days. This is from the program page that is available on the web at Public Procurement International. We talked about who's going to be presenting today. And then on Wednesday, we're going to have Jean-Jacques and Vinay Sharma. We're also going to be joined by a recent graduate of our program, Matteo Amerigo de Laurentiis, is going to be talking about a note that he wrote that was published in the Public Contract Law Journal on procurement at the World Bank. And on Friday, Professor Williams is going to be joining Prabat, and we're going to be discussing the developments in anti-corruption around the world as they impact on procurement and international development. And with that, I'll turn it over to Jun Jin from the UN Development Program.
Thanks a bunch, Chris. Thanks, Benedetta, for inviting me to join this exciting event today and share the virtual stage with Caroline and Benjamin. And seeing about almost 200 people on screen to talk about procurement on Monday must be an indication of something, perhaps maybe that the World Cup has concluded and there's nothing else for people to do. So glad for the timing on that to increase the participation for this event. So when most people hear the word procurement, they think of back office administration, they think about buying mundane office supplies. But as Benedetta noted, trying to provide some context on international development, procurement and international development is really about the physical manifestation of international law, of development policy, and human rights, all translated into action. So to understand the scale of procurement at the United Nations, the UN system overall procures about $25 billion US annually. More than half of that goes to vital services, with highest volumes focused on global health, on infrastructure, and transportation and logistics. At the UN Development Program, which is where I sit, we are the leading development organization within the UN and are one of the top 3 procuring agencies in the system, managing around $3 billion annually to help countries to achieve sustainable development goals. But we don't just look for the lowest bidder. Through our sustainable procurement strategy, we demand fit-for-purpose solutions, and we use our purchasing power to help build local markets, to support women-owned enterprises, and to enforce strict anti-corruption standards globally. Let us take stock of our current situation within the development sector. As Benedetta highlighted just before, we are operating in a drastically changed environment. In 2025 and 2026, we witnessed a historic collapse in official development assistance. Total foreign aid fell by nearly 25% compared to 2024, driven by massive pullbacks from traditional leading donors. And for the UN, that's meant that contributions have plummeted by about 27% compared to 2024, the largest annual drop on record. So this has forced the UN and certainly UNDP into a bit of survival mode. The budget pressure and the calls for reform are driving a profound reimagining in how we operate, including decentralization, including proposals to restructure and merge organizations within the UN and to consolidate how we do what we do, including how we procure goods and services. So because international aid is shrinking, this is something that we need to focus on even more than ever in helping developing nations to be better empowered and capacitated to manage their own domestic resources more efficiently and transparently. Good procurement prevents the leakage of already scarce domestic resources. So this is my call to action for all of you participating today. The developing world needs brilliant legal minds such as yours to help build robust institutional and legal frameworks in order to assess, design, and implement a procurement system that delivers value to its citizens. As development practitioners and organizations, we shouldn't just focus on dropping supplies into a country. We must support local capacity development and train professionals who can manage complex procurements long after aid money has dried up. So Chris, if we can move to the next slide, please. Thank you. So now I'd like to speak just a few minutes about procurement reform at the UN and what we've been up to over the last several years to evolve strategically to meet this moment. We've fundamentally reformed how we buy in several ways. One is on breaking down silos. So historically, the UN was plagued by and justifiably criticized for fragmentation. You had numerous different agencies operating in the same country, often buying the exact same goods, but running separate redundant bidding processes. So a couple years ago, the UN addressed this by launching this mutual recognition initiative whereby one entity is able to piggyback on the contracts of another agency to rely on the vendor assessments and the legal terms and conditions of another agency. And by doing that, we eliminated millions in redundant overhead. And so now collaborative procurement across the UN system accounts for more than $2 billion of our overall UN spend. And related to that, we also consolidated our global demand. So instead of piecemeal standalone procurements, we've created and made much greater use of long-term agreements, framework contracts, if you will, for high volume items like pharmaceuticals, solar panels, and the like, which force the market to give us unprecedented volume discounts. And we also realized that cheaper is not always better, right? Buying on the basis of low price isn't going to give you the long-term value that you might otherwise want. And so we modernized our legal and procurement frameworks to be able to calculate the total cost of ownership and best value for money to ensure that our investments are durable, environmentally sustainable, and actually effective on the ground. Over the last decade, we've also built a strong system of ethical accountability. We instituted a strict UN supplier code of conduct, which now incorporates into our general conditions of contract various rules against forced labor, bribery, and sexual exploitation, to name a few. And we also created a system-wide vendor ineligibility list. So today, if a corrupt supplier is sanctioned by one UN agency, that debarment actually is visible on the UN global marketplace and is recognized across the entire UN system to permanently shut down forum shopping by bad actors. We've changed who does the buying on behalf of the UN and how they do it. So procurement is no longer just a clerical job. We've transformed our workforce into highly skilled business professionals requiring strict, globally recognized certifications. And finally, we are digitalizing and accelerating the pace of reforms through the Secretary General's UN 2.0 vision. We're rebuilding our digital public infrastructure. And an example of that is at UNDP, we built a cloud-based enterprise resource planning platform that shares digital, financial, and operational services to over 70 UN entities. And that also helps drive consistency across the entire UN system for benefit to our vendors alike. We're also creating the Amazonification, if you will, of the UN, buying through B2B platforms like UN Web Buy Plus. And finally, of course, as Benedetta mentioned, we are experimenting with and integrating AI to help us to forecast demand, to detect collusion, and to audit complex supply chains. So to conclude, over the last several years, we have sought to build a highly accountable, efficient, effective, and tech-driven procurement system that we hope will be able to help the UN to weather the current storm and continue to deliver impact at scale. Thank you very much, and looking forward to the continued dialogue.
Thanks very much, Jun. We're going to circle back with questions at the end, but I really much appreciate your contribution. So now I'm going to turn it over to Caroline Nicholas and Benjamin to talk about the next steps in the reform of the UNCITRAL Model Procurement Law. Caroline?
Thank you, Chris, and good afternoon to everybody. It's a pleasure to be here. I'm just going to start by introducing UNCITRAL and the model law before Benjamin talks about the reform itself. So, Chris, you were kind enough to mention the work that we did nearly 20 years ago now on updating the UNCITRAL model law. So for those who don't know it, UNCITRAL stands for the United Nations Commission on International Trade Law. So it's part of the United Nations, and unlike the system that Jun was talking about, UNCITRAL, which is its acronym and how it's generally referred to, has a model law that is a template for national procurement legislation, the primary law. And the reason that UNCITRAL got involved in doing this was twofold. First, that it was viewed when UNCITRAL started working on procurement, which was back in the late 1980s, that procurement generally, public procurement generally, was not doing as well as it could be doing. So some reform and some standards to try and help drive up outcomes, particularly with concerns about anti-corruption as well as getting what governments needed, would be really very useful. And secondly, that there was very, very low cross-border procurement, and that there would be a potential to enhance the trade in public procurement. And both of those were viewed as critical to support one of the UN's main objectives, as you've heard earlier on from Benedetta and Jun, that is to support international development. So that's why UNCITRAL got involved. It issued its first public procurement text, which was on goods and construction only, in 1993, followed it with a model law on public procurement more generally, including services, in 1994. And then from 2004 to 2011, it reviewed that text completely and came up with a new model law on public procurement and a supporting guide to enactment. Now, the model law itself is a framework law. It's a template for the national procurement law, not a complete code. So it's quite short and it contains all the essential rules and procedures that you need for a primary national procurement law, and it's intended to be complemented by more detailed rules and regulations. And that approach is supplemented, therefore, by the guide to enactment that Chris mentioned, which is a very much longer document. It's several hundred pages long, that explains the policies behind the model law, how the model law implements them, and how to enact and use the model law itself. So you have the whole suite available on the UNCITRAL website, and we'll see a link to that in a little while. Very importantly, though, the UNCITRAL model law will only be any use to anybody if it can be used by countries that have all sorts of international commitments, notably the UN Convention Against Corruption, which just about every country in the world has signed up to now, and in nearly 50 countries, the World Trade Organization's Agreement on Government Procurement, to which both the US federal system and the EU as a whole in each of its countries have signed up. So the idea is to make sure that the text is internationally compatible. You can use it to fulfill your legal obligations with these other international texts, and that it's universal. And that's because it's designed to work anywhere. It's not designed as a US, European, African, or whatever text. And very importantly, too, it also takes account of the key features of the procurement systems of the multilateral development banks, again, so that World Bank and other bank borrowers can use the UNCITRAL model law and find that they're not having too much difference between what they do nationally and what the World Bank requires. It's therefore very widely used. It has the standard objectives that we all know: value for money, avoiding abuse, and promoting but not mandating international trade. The model law is a technical text. It's not designed to implement any particular government policy. It's designed to make sure that governments can implement the policies that they choose, and particularly tools to enable international trade, and not to cause obstacles to those. You also find on the UNCITRAL website guidance on regulations intended to support the model law, and very importantly, a glossary The idea behind the glossary is to deal with jargon. Across the different systems, we have various terminologies, and sometimes I've seen quite in-depth articles that have completely misread either UNCITRAL or the World Bank or another systems texts, and are comparing not like with like. So I highly recommend the glossary. Although it's a little bit out of date now, you'll be able to translate from the US FAR through the WTO, through the UN Convention Against Corruption, EU directives, and UNCITRAL, and so forth. And that package as a whole has meant that the UNCITRAL Model Law has become very much a leading international framework for this national public procurement legislation. When I was with UNCITRAL and now in the capable hands of Benjamin, there's also quite a significant amount of support to users from the UNCITRAL secretariat. Thanks, Chris. Next slide, please. So the text, as we mentioned, was issued in 2011. It was drafted in the years before that, so it's obviously a little bit out of date now. In 2024, UNCITRAL held a climate colloquium looking at how UNCITRAL texts might deal with the climate crisis that's facing us all. And it was suggested that perhaps the UNCITRAL Model Law could be updated with a focus on green procurement. In 2025, however, UNCITRAL in its plenary session, which is called the Commission, decided that it should have a broader modernisation, and that the UNCITRAL Model Law, in very much harmony with its previous policy or non-policy approach, it shouldn't be viewed as a text specifically to deal with green procurement or to deal with the climate emergency. So it was viewed as something that might perhaps be relevant, but the big focus would be a broader modernisation. Benjamin and his team have led consultations from the UNCITRAL Secretariat with various experts to try and understand what might need to be updated in the model law, very much on the basis that practice informs policy. So the consultations were looking at what's working, what's not working quite so well, what developments have we seen, and how should the model law be updated. But the idea behind it was not to completely rewrite the model law. Let's keep what's working well and update and modernise as necessary. And very importantly too, it may be that some of these issues do not need changes in the model law itself, but in the supporting documents. And in that, obviously, the core principles will be retained. Chris, next slide, please. So, as I've said, there were some secretariat consultations, and the Commission, UNCITRAL, has decided to look at having what's called a working group session in February 2027, next February, to look at updating the model law. Now, Benjamin's going to talk about some of the issues that they considered, but in practical terms, the importance of it going to a working group is that UNCITRAL has a very transparent, inclusive, and consensus-based approach to developing its texts in a working group. They're led by member states. There isn't really any practical difference between UN member states and UNCITRAL member states here. So view it as a UN member state approach to modernising the UNCITRAL model law. It will work on the basis of consensus. Consensus is a very flexible approach. That means nobody formally objects to any provision. And so the member states will look to find solutions to modernising the model law that everybody can live with, even if it's not their preferred approach. So the working group will meet for a week in New York in February, just 1 week. Then there will then be some recommendations to the Commission to see what it wants to do in July 2027 and see if any further work needs doing. You will find all of the documents on the UNCITRAL website. It looks like the web link itself is not very visible. I'll put it in the chat in a minute. And if you look at the Commission webpage, the current Commission webpage, you will see a document which has got a very long title there, document 1257, and you will see what has been considered so far. So that's basically the background and the history, and then I'm going to hand over to Benjamin, who's going to talk a little bit more about what's going to happen next. And as I say, I'll put the web links in the chat. Thanks very much, Chris.
Thank you, Caroline, and thank you, Chris, for the invitation. It's a pleasure to be here. It's an honor as well because I see many respected experts. So it's a very truly an honor to be able to benefit also from the network here, because indeed, what Caroline has said is that there is now this project going that has started to revise and update the model law on public procurement and the related texts. And maybe coming to the chat, I see already a question on what is a model law. A model law is really a template that states may use in their domestic legislation as a template, but then they really need to pass their own legislation or regulation or whatever it is according to the legal system to follow the procedures or the rules that are in that model law. But of course, they have all the sort of leeway that they wish. But of course, the idea, because of all the work that UNCITRAL has put into that, is really to try to follow the templates that UNCITRAL has adopted. You can see on the screen here the topic that were listed as possible topics for updates to the model law and the related text. And I think it's also quite interesting that because listening to what Jun said before, I see many topics that are indeed also part of the strategy of UNDP in terms of improving the procurement strategy. So I think it makes lots of sense, and it really means also that the UN is here very consistent in its approach, both at the operational phase probably, and then on the legal making process here in UNCITRAL. So I will not go into the detail of each topic. But as regard procurement and e-procurement and digital transformation, the model law already contained many elements regarding the use of IT, as we said before, in procurement. But now it's really about the digital transformation of public procurement with the use of platforms by procuring entities, the use of data and the reuse of data to improve procurement as well and to generate more efficiencies. There are also some countries where actually e-procurement is now mandatory. I've recently seen that in Bangladesh, and I think also the draft Chinese law, amended law on procurement, also mandates the use of digital platform in procurement. The second important point, especially also in international development, is of course the exclusion and debarment mechanism, the anti-corruption aspects. And here, what we witnessed is really this increased use of central registries, also interconnectivity between registries such as tax, beneficial ownership registries, and the procurement registries. And also a much more proactive approach by both the public sector and the private sector into identifying and excluding possible bidders and vendors. So I think there's also a lot of merits to probably update here the model law. We mentioned framework agreements. This was already in the model law, but apparently the practice revealed that there's lots of sort of privatization or marketization of framework agreements, and therefore the benefits that are expected from framework agreements do not always materialize because this sort of multiplication of platform and vendors platform and framework agreements that are run by private sector sort of make actually the life of many vendors and procuring entity more complex. And linked to that, the suppliers list or the certification schemes, which were not included in the model law, but which were discussed in the guide to enactment, have now gained lots of traction, and also because of the digital tools that are now available that really allow to have this kind of pre-screen list of vendors in a very flexible and transparent manner. We heard also about the use of non-price criteria for strategic procurement purposes. This is something that is also linked to the EU reform that is being now started. broadening the model law coverage to both the preparation of the procurement, but also to the procurement, contract management and administration. And here there's lots of lessons to be learned also from public-private partnerships, where UNCITRAL instrument on public-private partnerships cover those aspects and how you can improve both a probably value for money, but also transparency in those stages as well. And I think also I wanted to mention another topic that was a possible topic for update is the community participation, where I understand the international community is also very keen. And by community management, it's both the oversight aspects, but also the community being used as a bidder or as a maître d'œuvre to actually build an infrastructure. So that are a little bit the topics, and now we can move to the next slide. Please, Chris, thank you very much. During the commission session that finished 2 weeks ago, this paper was discussed, and there were much support to have a working group to discuss all those topics and how they can be now addressed in the model law and in the related text. The digital aspects, the fact that procurement still is the best way to deliver a good and well-needed infrastructure it was also emphasized. And also that procurement remains also in many countries the best market opportunity for many MSMEs. But I think there was also a cautious approach in terms of maybe having arbitration in procurement. So whereas how you can maybe challenge a bid through arbitration remains something that is probably very hypothetical. But of course, if we are talking about that contract management, arbitration would probably come into the picture. And mediation was quite well received, I must say. And expanding still the procurement cycle to contract management and preparation and pre-award as well was sort of flagged as maybe more like a policy issue or maybe too big to take on. There was also the need to sort of coordinate with the EU reform, and probably Chris, you mentioned that after. And like Caroline said, we'll now have this working group session in February, which will report to the commission session. And so what's next? Next slide, please, Chris. Really, here is a call for experts and everyone that is interested that the secretariat is now going through consultations with experts and with organizations. And so we are reaching out to many experts, but of course, if you are interested, you just feel free to contact us. And based on those consultations, we will prepare a paper with a possible updates, and those papers will be discussed in February 2027 in New York. If in the audience today we have NGOs which are interested to join the UNCITRAL process as observers to that working group, they should mark their interest already now or in the coming months. There is information on our website on how NGOs can become observers to UNCITRAL working groups. They need to be international, they need to be relevant to the topic that is being discussed, but we really welcome a participation of a broad scope of NGOs and observers to those discussions. So that's a little bit what I wanted to say today. And again, thank you for your interest, for your attention, and I'm happy to take on questions as well. Thank you very much, Chris.
Thank you very much, Benjamin. I'm just going to, and I apologize. I want to go back if I can just to Caroline's last slide here. Caroline, if you want to talk about this a little bit, how folks can get involved, just building what Benjamin said before.
Thank you, Chris. Yeah. Just to say, as Benjamin said, it's possible for international organizations, either international organizations, governmental organizations, or international NGOs, to take part in working group sessions. As Benjamin said, there's information about how to do that on the website. And that involves essentially sending a request to the UNCITRAL secretariat. And the idea here is to ensure that there's very good practical expertise from all over the world presented to the member states to consider and take into account as they decide how to update the model law. Very much the practice to policy approach that I mentioned earlier on. So individuals can't take part, as Benjamin said. There will be expert consultations, but individuals too can encourage their governments or indeed procurement-related NGOs, perhaps in their country that operate internationally, to consult stakeholders and provide the consultations, feed them into the process. Again, the idea is really to understand what's going on in the world and how the model law should or perhaps should not reflect those practices. And I've just put the UNCITRAL secretariat email on the bottom there. But please, before anybody inundates UNCITRAL and Benjamin with their points, take a look at the website and you will see how the system works in quite a lot of detail. So with that, I'll stop there. Thanks very much, Chris.
Thank you, Caroline. So I wanted to wrap up before we go into the group discussion. I just want to wrap up talking about some of the major procurement reform efforts that are going on. So as Caroline and I are working on the most recent iteration of the UNCITRAL Model Law that was published in 2011, and we worked together with a very large group of procurement experts from around the world on the accompanying guide to enactment. It's about a 300-page guide to enactment. And what became very clear in that discussion is that no procurement effort is an island working on its own, that all of these procurement efforts are interacting and they speak to each other. So it's important to keep track. There's actually, in addition to this, we'll be talking about this with Shope, and I apologize that she's actually in the process of moving to Washington this week, that there is a fifth effort, which is the South African reform. South Africa has a very ambitious procurement reform statute in place, and it's developing implementing regulations and is bringing together Shope has been involved, and Geo Kino, who her colleague at Stellenbosch University, have been involved in bringing together lessons for the South African reform. Among these four here on the screen, I just want to touch on these. We've been talking a lot about the UNCITRAL effort. We've also in the chat we've had a discussion of the Model Procurement Reform effort. So the Model Procurement Code is used by 17 states of the 50 and by hundreds of local governments and tribal governments across the United States. And it was last updated in 2000, and now it's being updated again for the first time in over 25 years. And that effort is under the American Bar Association. It's being coordinated by a nonprofit called Partners for Public Good, and they're doing an extraordinarily good job in coordinating that effort with scores of lawyers and procurement professionals across the United States, including many from the National Association of State Procurement Officials, or NASPO. What's coming out of that is that for instance, there are elements of anti-corruption. There are strategies for anti-corruption that really work at the state and local level that are unknown in the U.S. federal government. For example, constraints on improper communications during the competitive process. So that the Model Procurement Code reform effort is generating lessons that could be used in other nations. Where Caroline and I, as I mentioned, we're lecturing in Kosovo on Friday. A lot of the issues that they face in Kosovo are many of the same issues that state and local governments face here. So there's a very useful interchange. The Trump administration is revising the Federal Acquisition Regulation. It's about a 2,000-page regulation that has 250 years of history behind it. It really can be traced all the way back to our Revolutionary War in the 18th century. That has been controversial in part because there wasn't a regularized notice and comment process early on. It is now going through notice and comment, and there's a great deal of work being done on those revisions. I think what be most immediately relevant to global reform efforts is the training that's coming out of that. There's training being developed on a very rapid basis using artificial intelligence, and it really is a precursor. Benedetta talked about the impact of AI on our work. that training, because it can be done so rapidly and so malleable using AI, it's really a precursor to using AI as a way of assisting procurement officials, not in just in generalized training, but in particular problems that they may be encountering on a day-to-day basis. So the use of AI for training, for implementation in the U.S. It's what's called revolutionary fire overhaul. That carries very important lessons for the international community. The last is the European Union's proposed reforms, and that's the Public Procurement Act. There's a link on the program page to what appears to be a leaked version of the European regulation, the European Union regulation. That Public Procurement Act, in whatever form it's going to take, is due to be published in September, and we'll be having a webinar on October 6th. The shift from the current EU directives to an EU regulation is really going to be profound because it'll mean that we'll have one consistent law. Regulation is binding across all the member states and will have real impact on the European Free Trade Area, the EFTA states, and on the potentially ascendant states with association agreements primarily in Eastern Europe. So this change that creates a uniform procurement law across Europe, really more broadly across Europe, not just inside the European Union, could have a very important impact. And as Benjamin mentioned, the UNCITRAL effort will be monitoring those developments. And again, by September, we should have a clear vision of where that's going, and we'll be having a webinar with that on Gabriela Raca, my colleague at the University of Turin, and I will be hosting that in October. So we got a question in the chat about national preferences, and I just want to open up the Q&A by talking about this issue because probably the most important aspect, or certainly the part that's received the most press, is that the draft European regulation that was apparently leaked, it would have a very strong European preference in it, a presumptive preference for European products and also for products from nations that have trade agreements with the European Union, such as the United States and other nations, such as Canada, through the government procurement agreement or through bilateral agreements with the European Union. And the question that we had in the chat is whether or not we're seeing that type of domestic preferences in other areas as well. And Benedetta, I wonder if you want to speak to that, how you see domestic preferences emerging in this mix of international procurement.
Thank you. Can you hear me?
Yes.
Thank you. I was actually about to interject and comment on this point. I think there has to be, if I just focus on the UN system, the issue of buying local is a relevant one in many projects that are implemented by various UN organizations, but the way it is handled, it is usually done on a case-by-case basis in the sense that very often it is included in the project agreement, in the project document, in the agreement with the donor, that any goods that will be used in support of the project will be purchased locally. And there are some requirements that are included. But again, it's a decision that is normally taken at the project level. You wouldn't see like just a blanket preference to have products purchased locally, within UN implemented projects. On the flip side, in the UN system, if a donor requests that products only be purchased from companies of the donor country, that request would normally not be accommodated. And so again, it's important that goods be purchased locally when there is a requirement in the project agreement. But again, with some restrictions and always, the exception that if no effective competition can be reached at the local level, that the international suppliers be allowed and invited to bid.
Caroline, I wonder if you could speak to this. So the history for the group on the UNCITRAL model law, we had when we were working on the UNCITRAL model law between 2003 and 2011, there was a lot of resistance from our European colleagues to having preferences built into the UNCITRAL model law. But many of the developing nations, they just literally turned around in the room. They said, "You, the United States, in the back. What kind of domestic preferences do you have built in? What kind of socioeconomic preferences do you have built into your law?" And so I took a little time and I stood up and I spoke for like 8 minutes, just listing all the domestic preferences that we have in U.S. law, which made it clear that at least one of the partners to the UNCITRAL effort had significant preferences. Caroline, we ended up in a position, really a process solution. The process was solution that's in the current UNCITRAL model law. It says you can use domestic preferences, but if you have preferences or other domestic preferences or other socioeconomic preferences, they just have to be clearly set forth in statute or regulation. It's a process requirement as opposed to a substantive requirement. Do you see space, Caroline, for expanding a domestic preference provision in the UNCITRAL model law?
Thanks, Chris. It's a very good question. And as I've mentioned in the chat, the UNCITRAL approach is very flexible because UNCITRAL recognizes that this is a policy question for national governments. So the caveats to using the model law and having preferences in the model law are that they've got to be fully transparently disclosed like any other award criteria. They've got to be legally authorized, as you've just said, so not some whim of a procurement official. And they've got to be compatible with your international obligations. So for those who've signed up to the WTO's Agreement on Government Procurement, who are part of a regional free trade agreement that covers public procurement, or perhaps in World Bank borrowing and so forth, they're generally not permitted, subject to thresholds and so forth. And I think there's a bit of policy tension here, Chris, between states that everybody knows wants to use these things to some degree, and an international community that was historically very anti-preferences. And that's not just politics. A lot of that is because the evidence is that preferences, once they can be introduced to promote and protect developing national industries, but they do tend to persist well beyond when they might be useful. They're often traditionally not been transparently disclosed, and they've had very poor impacts on competition in some areas. So whether or not they're a good idea is actually quite a nuanced question. But let's be honest, all politicians like to say they will support domestic local industry, small industry. So everybody's going to be using them. I think the best thing to do is, if people wish to use them, very important to use to gather data on how they impact your procurement, and then you can look at a cost-benefit analysis. But again, I haven't found many politicians who are very willing to engage in that particular cost-benefit analysis. Thanks, Chris.
Thanks very much, Caroline. We're running out of time, so I wanted to ask one question because a lot of the challenge in working this area as lawyers and working with policymakers is trying to anticipate the practical changes that are taking place so that the law can align with what's happening, practically speaking. So I have a question for Jun because he's really in the midst of this at the United Nations. Jun, you've heard that the UNCITRAL model law is going to be looking at digital transformation. For the European Commission, if you look at the draft regulation, the memorandum that accompanies that draft regulation that was apparently leaked, that's digital transformation is very important. So the question for the procurement community, Jun, is as we're thinking about digital transformation, and importantly, for the kinds of digital exchanges that you were talking about in the UN context, what will be likely the first focus of those digital exchanges? Would there likely be a focus on contractor qualification information? Who's the corrupt contractor? Who's the inept contractor? Or will there be other kinds of information being exchanged across borders and between institutions? What do you think the first focus will be?
Yeah, thanks for that question, whomever, and for raising it, Chris. Yeah, I mean, I think as it relates to some possible areas for moving the needle, as I mentioned before, the UN did already put in place a system-wide ineligibility system, right, which wasn't in place, despite what you might assume that was not something that was part of the system when the UN was created many years ago. It was more recent when this was identified as a problem, and so the UN, the global marketplace, was really the platform which allowed UN agencies to identify vendors who were subject to sanction and to then render them ineligible system-wide. So that was a relatively recent construct. I think the idea of possibly expand, and that does apply also. So we take debarments from MDBs as well into account. So if you're debarred by the World Bank, for example, that would also apply to your ability to do business with the UN. So that came into place. I think it's a little more challenging to do it across other organizations, if that's part of the question about, whether if the EC were to debar a vendor, that's not something that the UN would be able to easily take on because the different standards. The US also has its own debarment regime, which was designed in part for a different purpose. So to apply different legal standards for ineligibility across the board might present some challenges. But it is an area where I think I'm also thinking about the push to eradicate and take on the problem in the development sector and humanitarian assistance space about preventing sexual exploitation and abuse. And so there has been a push. We have a clear check process that within the UN, if an individual or an organization is found to have engaged or been complicit in SEA or SH type activities, that may also render them ineligible. And this has been kind of a concerted effort, including with the NGO community, which creates its own challenges because what the NGOs might like to see and what we are legally able to do as a UN agency that provides and has to provide due process to vendors. It can create some challenges if you're talking about sharing that information in a way that could be of value to others. Thank you.
Thank you very much, Jun. Benedetta, any last thoughts?
Thank you, Chris. I just wanted to take the opportunity to thank the panelists today and also those who have attended this presentation. We've talked about institutional fragmentation, the changing cast of actors within the international development community, and also the prominent technology question that is going to inform how procurement in international development is going to be to evolve over the coming months and years. Thank you again for your questions. Feel free to follow up with any one of us in writing if you want to. Our LinkedIn profiles are open and accessible. And again, I hope you'll be able to also join the remaining sessions of this series. Thank you again.
Thank you, Benedetta. We look forward to seeing everybody on Wednesday. It'll be at the same time, 9 o'clock Eastern, 1500 CET, 1830 in India. And we really have participants. We've had participants from around the world, and we've had really interesting questions. We appreciate your participation and all the interesting questions we've gotten to the chat. Thank you again to the panelists. And again, I look forward to seeing you on Wednesday. Take care. Bye-bye.
Thank you all.
Thank you.
Thank you, everyone. Cheers.
Thank you, everyone.
Bye-bye.